This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance, explaining again why failure to read defeats a suit made by an insured against its insurer and insurance agents, and that the payment of a renewal premium is acceptance of a policy as written. Ronald Morgan and Cheryl Morgan appealed from the trial court's grant of summary judgment in favor of Dickelman Insurance Agency, Inc., Dickelman Insurance, Inc., Jason Dickelman, and State Farm Fire and Casualty on the Morgans' complaint for breach of contract, promissory estoppel, negligence, and fraud. In the case entitled Ronald Morgan et al. Versus State Farm and Dickelman et al., a December 30, 2022 decision of the Court of Appeals of Indiana, the appellate court made clear that an insured is required to protect its own and their own rights by reading the renewal notice of a policy. Finding that the facts most favorable to the Morgans, the Court of Appeal noted that the Morgans as nonmovants show that in 2007 they purchased a log home in Lafayette, Indiana, and in 2008 they acquired homeowners insurance with State Farm. The Morgans paid insurance premiums through escrow funds held by their mortgage company. Each year, State Farm mailed to the Morgans renewal notices that the insured did not recall even looking at. Dickelman, the State Farm agent, contacted the Morgans several times between 2011 and 2014 to sit down and meet with him, but they did not respond, and they never met with Dickelman to discuss their insurance coverage. In May of 2012, Cheryl read the log homes could have higher replacement costs than ordinary houses and became concerned that their home might be underinsured. Cheryl called Dickelman Insurance and spoke with a female insurance representative. Cheryl initially requested a $250,000 increase in dwelling coverage, but the representative told her that that was way too much. There was no evidence in the record as to the amount of the higher premium. Cheryl never confirmed with Dickelman's office whether the requested additional coverage had been procured. In 2015, the Morgans submitted a claim to State Farm for extensive water damage to their home, with a repair estimate of $712,000 to $800,000. Ultimately, State Farm paid the Morgans $330,034.88 for the claim, which represented their dwelling coverage limit for the policy period when the loss occurred, plus inflation guard protection and the cost of debris removal. On September 20, 2017, the Morgans sued the defendants, alleging breach of contract, promissory estoppel, negligence, and fraud. The trial court issued an order granting summary judgment for the defendants on all of the Morgans' claims. In their complaint, the Morgans alleged that the defendants breached an oral agreement to increase their dwelling coverage by $150,000. In an affidavit, Dickelman attested that the Morgans never authorized Dickelman Insurance to increase their dwelling limits. Thus, the defendants' designated evidence established that they did not commit breach of contract. The basic requirements, of course, of a contract are offer, acceptance, consideration, and a meeting of the minds of the contracting parties. The general rule is that delivery of a policy by the insurer to the insured upon the expiration of a policy without a request by the insured is an offer which must be accepted by the insured before a contract of insurance is effective. In this case, State Farm mailed renewal certificates to the Morgans that clearly and unambiguously informed them of the amount of their policy dwelling coverage. In Indiana, and in most states, insureds have a duty to read and to know the contents of their insurance policies. A casual scan by an unsophisticated customer of the first page of the 2-page 2013 renewal certificate would inform that person that the dwelling coverage was limited to $297,100 and that the premium charged was for this amount of coverage. By retaining the policy and paying the premium, even though through an escrow account held by their mortgage company, the Morgans accepted the offer to renew at $297,100. No mention made of the requested increase. Insureds in Indiana and in almost every state have a duty to read and know the contents of their insurance policies. The traditional rule is that reliance upon the representation of another is not justified where the injured party has a written instrument available and fails or neglects to read it. The rationale for this exception to the general rule that one has a duty to read and know the contents of one's insurance policies is that an insurance contract is a detailed and complex instrument drafted by expert legal counsel and has been called a contract of adhesion for the reason that the insured is expected to adhere to it, as it is, with little or no choice as to its terms. In addition, as I explained in my brand new book, a compact book on how judges read, understand, interpret, and rule on insurance policy issues, an insured rarely reads the insurance contract. And even if the insured did read the policy, it's doubtful that he or she would gain more knowledge because of the technical language. Yet the insured is obligated to know the non-technical parts like the policy limit and premium. Insureds may not read insurance policies. In fact, most do not. But they do read the bill, and they pay it. And in this case, the Morgans read their bill, and they caused it to be paid, and they accepted the policy as the renewal order showed. This case involves an unambiguous dollar amount that appears on the first page of the renewal certificates. At least under the facts of this case, the dollar amount does not qualify as technical or complex language. And they admitted they didn't look at it. If the Morgans had just glanced at the first page of the renewal certificates, they certainly would have immediately recognized that the coverage limit on the policy was not what they thought it was to be. As a matter of law, the traditional rule that reliance is not justified where the injured party has a written instrument available and fails or neglects to read it applies. The renewal certificates were simple, and the amount of dwelling coverage was unambiguous. Had the Morgans looked at it, just looked, they would have seen that their coverage had not been increased by the $150,000 amount, and therefore the Court of Appeal concluded as a matter of law that the Morgans' reliance on the defendant's alleged statements was not justified. My new book is available at Amazon.com and explains why an insured is obligated to read and understand, at the very least, the non-technical part of their policy. Ignoring renewal notices, paying premium based on those notices, and ignoring the fact that the limits were not increased nor was the premium increased is not the basis for a claim of breach of a clear and unambiguous contract. And that after paying the full policy limits, the insurer was still sued, claiming breach of contract and fraud because the insureds refuse to acknowledge their own error and lack of concern for their obligations as insureds. The good deed, the payment by State Farm, was punished by the filing of this lawsuit. Insureds must read their policies, and if they don't read them, at least read the renewal notice that says how much your coverage exists. I may be unusual because I do read my policies, and I don't read them all because I've read and written insurance policies. The Morgans just sat on their rights, ignored their obligations, and as a result, they lost their lawsuit. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and receive notices every day because I publish at least one blog posting a day, 5 days a week, sometimes even more than 5 a week. You can also subscribe to the rumble.com blog or to the video at youtube.com, and I'd appreciate it if you click on the like button and the Rumble button if you watch on Rumble. And you can subscribe to those videos. And if you found the videos or the blog postings to be interesting or useful to you, please tell your friends and colleagues so that they can also subscribe. Thank you for your attention.